Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m. here on the Bottled Business Sense show. For our returning viewers and listeners, welcome back to the Bottled Business Sense show. We are a business simulcast show that shares legal topics on how to protect your business, run it efficiently, as well as sharing marketing tips from a video marketing and general marketing standpoint. That's my expertise. My name is Rick Moscoso, and on the other side is Mr. Bill Bernard, and we'll introduce him here in a second. But for any of our viewers out there, we welcome your comments, your feedback, and if you would like to be a guest on the show as well, go ahead and send an email to us at bottledbusinesssenseshow@gmail.com. You can also reach out to us on social media, on Facebook, Twitter, Google Plus, at the same handle. We would welcome your feedback, and we look forward to maybe connecting with you in the future and being a guest on the show. So we're back again here on Tuesday, and Bill on the other side is raring to go with his topic. So let's let's bring Bill on and welcome him. So how are you doing today, Bill?
Yeah, good morning, Rick. Yes, we're ready to go as usual. And as you said, the show prides itself on, one, giving free information to business owners and entrepreneurs, no matter the size, and two, providing you a vehicle or vehicles in which you can grow your business while keeping it safe and protected. And that's the bottom line. So we intertwine asset protection principles in general, estate planning principles, and also employment law, which plays a big part in keeping a business safe if you follow the rules and regulations, because a lot of businesses, as they do prosper, start to hire employees. And I thought today we'd talk about, the title of the show, let's start with that. It's a start early, keep it simple, and don't try to hide assets from your creditors. I've thought a lot about this, Rick, and, there's an old saying, there's a gambling saying, actually, that goes something like this. If you want to be a winner, you have to walk away from the table a winner. Honored method of reaching this result is to systematically take your chips off the table as you win, so that your potential for losses stays small. Well, a lot of people, should follow this in everyday business life. And when you think about asset protection, it's really about planning and taking your chips off the table in good times so that when you can walk away from the table a winner, you do so no matter what happens in the bad times. That's really a way to sum it up. I thought it might be valuable to provide some tips to people who are not just big-time obstetricians or real estate investors or lawyers or anything like that, but average folks who sometimes get caught up in difficult situations, who may run a business that's highly prone to being litigated or sued. And even if that's not the case, for the worst. Really, asset protection planning is a debtor's side of creditor-debtor law. So, in other words, while creditors are concerned about the strategies and techniques of collection, debtors are interested in the strategies and techniques for protecting their most valuable assets from. So, having said all of that, I thought it might be good to tell everybody what they should keep in mind and what the general rules are that are applicable for taking your chips off the table, if you will, so that you don't suffer in the bad times.
I think Kenny Rogers had a song to this saying.
Yeah, we're not going to have any duets or duos or anything else on the show. We're not going to have any vocals, nothing like that. Really, we're really just trying to give some straightforward business tips. If I was a singer, I'm sure I'd be doing a lot of other different things besides providing our potential clients free information. Not that I don't enjoy that. I do very much. So let's get started. Start number one. Well, let's number these. We can make them bullet points. And number one is start planning before a claim arises. Many things you can do will be effective in providing asset protection before a claim or liability situation arises. But few things work afterwards. That's because what you do after a claim arises can be undone by fraudulent transfer law. Protect your assets legally and safely beforehand, and you try to protect them later on, the fraudulent transfer law could come into play. A court could challenge your transfer of assets, negate it, and then they'll be exposed for a recovery from the other side. So the point at which a claim arises is earlier than a layperson might think. It is, for example, usually much earlier than when a demand letter or process server shows up at your door. It's really when you are aware that somebody may be having a dispute with you, and it may involve a large part of your assets or even a small part of your assets, really. And now you have a sensitivity towards something that needs to be done in order to protect them. In other words, you're thinking about protecting your assets after the fact, and that's a bad thing. And that really leads into number two, which is late planning usually backfires. Here's what I mean by that. Asset protection planning after a claim arises is apt to make matters worse. Think of it like getting a flu shot when you have the flu makes your situation even worse. It is a common misconception, Rick, I should say, that the only thing a judge can do is unwind a fraudulent transfer, leaving a debtor who unsuccessfully tried late planning no worse off than he had as if he had done nothing. To the contrary, both the debtor assisted in the fraudulent transfer can become liable for the creditor's attorney's fees, and the debtor can lose hope of getting any discharge in bankruptcy, even if that was on your mind. So remember, there's a twofold issue here. If you plan late, they can accuse you of a fraudulent transfer. They can take you to court. They can get that transfer overturned. It also prevents, and I'm not a big bankruptcy fan, but if bankruptcy is your only way out, remember, fraud does not protect you from bankruptcy. A bankruptcy court will not allow you to hide assets if there is a claim of fraud made against you. So bankruptcy's gone. Boom. That's not an issue. So late planning usually backfires if you try to do it after you know a claim is headed down the pike. Another misconception, I'd say this is bullet point number 3, is that asset protection planning is not a substitute for insurance. Asset protection planning should not be a substitute for liability and professional insurance, but rather should be a supplement to your insurance plans. It's a myth that asset protection plans invariably scare plaintiffs away, and an asset protection plan doesn't pay any legal fees to defend against a lawsuit. Insurance can supplement an asset protection plan since it can help a debtor survive a claim of fraudulent transfer. If you get sued, let the insurance company pay to defend you for the claim and pay to settle it. That's what you pay your premiums for. Okay? So remember, asset protection, when you emphasize, as we said in our very first show some years back, when you form a business entity, that business entity relegates claims to your business and protects your all assets, home, well, your home is your house. So any of those types of things. The insurance will protect your business assets minus the deductible. So if you have an asset protection plan instituted, that's great. But also have insurance as a supplement so that somebody comes after your business, the insurance can pay the claim, deductible is, and the insurance company will many times hire a lawyer to represent you who you do not have to pay for that representation. So, and I think we did a whole show on this, the difference between asset protection in its purest nature and insurance, because people were giving me questions. Well, why I have insurance? Why do I need the other? Why do I need one? Why do I need them both? I have one or I have the other. You need the asset protection plan in the form of a business entity to protect your personal assets. You need the insurance to protect your business assets. I hope that's crystal clear to everybody because it's a really important concept. So make sure you have insurance as a supplement. Point I want to bring to everyone's attention is that personal assets are for trusts and business assets are for business entities. This leads right into what we said a few minutes ago. Business entities such as corporations, partnerships, LLCs are meant to be vehicles for commercial operations, not to act as personal piggy banks. They protect your personal assets, but when your personal assets are placed in your business entity, the potential for the entity to be pierced by a creditor on some other theory, such as alter ego, increases exponentially. In other words, if you put your personal assets, which your business entity protects, if you put them in your business, they're no longer your personal assets geared toward the protection from your entity. They now are commingled and become part of your business assets and will be covered only to the extent any insurance plan provides. So you want the business entity to protect your personal assets, but to pass your personal assets and to avoid probate, you want a living trust because the trust will allow your personal assets to pass free of probate and the costs and expenses and attorney's fees of probate. But you don't want your personal assets in your business, such as an LLC or corporation, because that is commingling. So you have to remember the distinction when it comes to personal assets. You have to remember the distinction between trusts and business entities. Business entities protect your personal assets as long as you don't commingle them with your business assets. And trusts are to pass your personal assets after your death. Trusts are not to be used to protect personal assets. So, a common misconception, and it's very, very important to understand for people who are involved in asset protection planning and estate protection planning. That's why I do both, and that's why they're so intricately involved.
Yeah. Let me just make a comment to that because this can be a little bit confusing, but just to reiterate what Bill has shared here, that it is extremely important, vitally important that you pay attention to early preparation. I think that's what Bill is stressing here. You got to be prepared if you're going into business. You got to be prepared for any situation that could put you at risk of being sued. And in order to understand how to protect yourself thoroughly, in both of these situations that you brought up, it's really mandatory in my thought to be having a discussion with your attorney or have a discussion with Bill, so you are totally protected all the way around.
Right, and that's why businesses need attorneys from day one. You shouldn't wait till you get into trouble. And it's worth just recapping these first 4 bullet points. And that's why I urge anybody who's listening or watching the show to take notes, make bullet points. 1, start planning before a claim arises. 2, late planning usually backfires on you, okay? Number 3, asset protection is not a substitute for insurance. And number 4, assets are to be passed through a trust, not protected by a trust. It is a business entity that protects your personal assets and an insurance plan that protects your business assets. It's really that straightforward, and it's not too difficult to comprehend. The next bullet point, number 5, which is too much control, is a bad thing, believe it or not. As asset protection planning attempts to reach a balance, in other words, between giving a client sufficient control so that the assets do not disappear, but at the same time, not too much control so that a creditor can successfully argue that the debtor and the asset protection structure are effectively one and the same and thus should be disregarded by way of some alter ego theory. The alter ego theory being that your business entity or whatever asset protection vehicle you're using is just a farce. It's just a fraud. It's just a screen to protect your assets when actually it's not operating independently as a business entity. So remember that there are a number of ways to give up control. And this leads into a whole array of intricacies and ways to do this that you need to speak to a lawyer by. A lot of times you can, for example, you can transfer some of your assets to put them solely in the name of your wife, your spouse, your husband. But if you do too much of that, then it looks like you're intentionally trying to avoid some sort of a potential claim down the line. If you do it gradually and you do it to where it's about equally balanced, that's a way to protect your assets by transferring it to another party. Same way with a irrevocable trust. You can bring your assets in an irrevocable trust now as opposed to a one that you can revoke. And now the trust will own your assets, and the trust will, in fact, in that situation, not only be a vehicle for passing your assets when you die, but that type of a trust, an irrevocable trust, will, in a lot of instances, provide you with asset protection as well. But that's not the more common type of trust. The more common is the revocable trust, which will not provide you with asset protection. So in order to get asset protection by way of an estate planning issue, you need to have an irrevocable trust done. They're intricate, a little bit complicated for the layperson, and definitely require an attorney's attention, the personal attention of an attorney.
Yeah, folks, the beauty of Bill's, sorry to interrupt, Bill, but go ahead. I want you to interrupt. Yeah, I just wanted to share with our viewers now. Bill's covered a lot of different things here and just skimmed over a few of them. But, fortunately for our viewers and listeners out there, we have full episodes on some of these things, a lot of these things that as Bill is sharing. So if you just take some of these keywords and enter it in our search bar on our website, you'll see all the episodes relevant to what Bill is speaking to in a detailed fashion.
Yeah, and you can go ahead and get a consultation with a lawyer, because you can if you get the right lawyer, you can discuss asset protection principles and estate planning principles all with one attorney. Because many times now, and this has been recent case law, a lot of attorneys are responsible for knowing asset protection if they're an estate planning attorney, and responsible for knowing estate planning if they're an asset protection attorney. They're very, very, very much related, and so consequently, himself in a bad position if in doing estate planning or doing asset protection, he is unaware of the effects that this plan that he's improvising and implementing for someone may have an effect on the other issue. In other words, estate may have an effect on asset and vice versa. So you need to have somebody who's well versed in both of those areas because they are brothers and sisters. Number 6 would be asset protection planning and tax and estate planning don't always jive. What do I mean by that? Well, often asset protection and estate planning together work just fine, but sometimes they are at odds. And what would be a good idea for an estate plan may not be such a hot idea for asset protection. Let me give you an example. If you are making gifts to your children or other prospective heirs during your lifetime, which you're allowed to do and which is non-taxable, which is very common in estate planning. Asset protection planning gifts can often be set aside as fraudulent transfers. So you need to make sure that you follow asset protection planning principles and not making a fraudulent transfer, but keeping it within the bounds of a gift that's legal and not taxable by way of estate planning. How do you do that? You plan early. You follow the rules that provide up to roughly $14,000 a year in gifts. and you do it presumably on a consistent basis, but do it at a time when you don't see anything happening down the road. If you do have an inkling that something is happening, then forego making a gift for that year or subsequent year, or however long it might take. So this is, again, another example of how you have to be aware of the interaction, the intertwining between estate planning and asset protection. And it takes someone who's able to form your business entity and form your estate plan in such a way that these two do not conflict. That's just very, very important. We oftentimes hear about a lot of offshore investing and offshore protection. So bullet point number 7 would be your money may be offshore, but don't forget you're here. You're here in the U.S., right? So recent cases have recognized the power of courts to require debtors to bring their money back to the United States, and this is known as a repatriation order. If the debtor does not comply with a repatriation order, a court may issue a bench warrant for contempt of court, contempt and in jail until the money comes back. Remember that a corporate lawyer let's not name her, but she's a corporate lawyer, and she was in jail for 14 years. 14 years by refusing to comply with a repatriation order, ordering that money from overseas be brought back. So here's the thing. No one can force you on transfer. Let's assume this isn't a fraudulent transfer, that you have money offshore and that a debtor now has got a judgment against you and wants to recover it. Well, if it's not a fraudulent transfer and you've done this long ago, they can't force you to bring that money back. But if the court orders you to do so and you do not, the court can then say, well, we'll hold you in contempt of court. And guess what? For contempt of court, we're going to throw you in jail. And while we can't force you to bring that money back, we'll keep you in jail until you decide you will bring it back. So don't always feel that your offshore investments are protected. The U.S. government and the IRS is cracking down on these offshore vehicles in order to force these governments to comply with IRS regulations from another standpoint as well. That is to say, we won't cooperate, we won't provide you with aid or anything else that you might need from our country if you don't comply with our IRS regulations. So don't think that your money offshore is a way to go in and of itself. This is something near and dear to a lot of business people's hearts. In fact, I just came across it twice in the last month, Rick. And that's bullet point number 8. Don't count on bankruptcy as a last refuge of a desperate debtor. In 2005, and I'm not a bankruptcy lawyer, but I know some general principles. In 2005, the bankruptcy laws changed to become a cold acid bath that leaves debtors with bare bones and little flesh, if you want to put it bluntly. State homestead exemptions have been substantially limited, and other provisions of the bankruptcy code make parts of asset protection plans very difficult to protect in bankruptcy. Bankruptcy judges have very strong powers to make debtors cough up assets, and one of them that I spoke about is this fraudulent transfer issue. So bankruptcy was mentioned a little bit earlier, but it's worth noting individually here in bullet point number 8, because I want people to understand that they should also consult with a bankruptcy lawyer if indeed they're contemplating that down the line. Get your asset protection and estate lawyer on board, get him to do what you need to do. If for some strange reason you contemplate bankruptcy, which most likely which you will most likely try to be dissuaded from doing by your estate and asset lawyer, then certainly by all means go see a bankruptcy lawyer before you do anything at all, because it can affect you down the line for many, many years. As we move towards the close of the show, number 9 is, if you can't explain it, it will never work. If you can't explain it, it will never work. Many asset protection plans become so complicated that not even the client can explain how assets are held or how those assets were transferred. But I'll tell you, such questions can be expected in depositions or a debtor's examination, and a failure to fully and clearly explain what happened and why will make the court very, very suspicious and potentially give the court grounds to begin disregarding entities or setting aside transfers. Most judges, Rick, start with asking themselves, what's really going on here? If the structure and the transfers are too complicated and not well explained, there's a much higher chance that the judge will find fraud and indeed set it aside. So remember, you need to have this stuff very simply put out there, and don't try to hide it. If it's done the right way, your assets are going to be protected, your estate's going to be protected. And that finally leads us to number 10. I'm sure you have no idea what that number 10 is, right, Rick?
No clue, but go ahead. You're going to share with us.
Usually everything sees the light of day. Want to end the show.
There's a little optimism in this.
There's a lot of optimism there, yeah. Asset protection, this flows right from what we just said a minute ago. Asset protection planning should be based on the presumption that the entirety of the planning and its purpose will eventually become known to creditors. Somebody should find out about it, or will find out about it, because one way or another, that can happen. Asset protection plans that require secrecy will face a plethora of problems, from how not to disclose the structure or activity on tax returns to how to keep a mad ex-spouse or disgruntled employee from talking to creditors. And don't even think about going into bankruptcy without making a full disclosure about your assets and your transfers when you attempt to do so. The failure to make a full disclosure will usually lead to a denial of a discharge in bankruptcy, and the failure to make truthful disclosures can even amount to, guess what? Bankruptcy fraud. Imagine if you have made a fraudulent transfer, and now on top of that, you're lying to the bankruptcy court. Now you can be held for bankruptcy fraud on top of everything else, if everything else wasn't bad enough. And of course, charges of perjury. So these are not something that this is not something you want to take lightly. And I think it's worth mentioning on the show because many people don't take this to heart. And I don't think you have to be a millionaire or a billionaire or a trillionaire to be able to take advantage of asset and estate principles. I've been preaching that from day one. But what you do need to do, whether you're middle class or very wealthy, you need to plan ahead of time, make sure that everything sees that light of day, because eventually it will anyway, and make sure that everything is on the up and up, and that you do so over a course of time before a claim arises. And if that doesn't get people like Rick to yawn, I don't know what will. But I think it's worth mentioning, folks, that personal assets are certainly worth protecting. And if you follow these simple 10 bullet points, I think you'll be just fine. Remember, they are straightforward bullet points, and they're not very difficult to implement with the correct lawyer's guidance.
That's right.
So,
well, folks, I hope you were taking notes on that. I was jotting down a few here myself. Although I have heard these in detail, it's always good to review and make a mental note on these, because you just never know if a situation like this, God forbid, would ever come up in your business. Be prepared, like Bill says. The early bird, that's prepared, I guess, is what this story is all about. So,
you know yourself, Rick, that you've got an LLC. Why don't you tell our viewers why you decided to get an LLC?
Well, without getting into some of the details, Bill is
let's get into the details. They're important. The details are very important, and that is that you wanted to ensure that your valuable assets are protected, right? I mean,
the bottom line is that. I mean, Bill has been preaching it for a long time, and I was a little slow in the beginning to make the move to do it, but I saw the value in it, and I'm glad I did it, because I feel much more comfortable now that I am protected and can focus more on what I enjoy doing without.
And you didn't do it because you felt. Tell everybody. In other words, you did it well before any claims came down the pike against you, and in fact, you have no claims against you. Let's make that clear. But you did it at a time when you knew it would be early. You did it at a time, and this is what I'd really like you to tell everybody. Tell them whether or not you found it to be a difficult thing to do.
Oh, well, absolutely not. I mean, I was not at all knowledgeable in the mechanics behind it, nor was I willing to call myself an expert or do it myself. And so that's why I hired Bill to, help me out and take care of that. And the process was probably one of the most easiest legal things I've ever had to do in setting up my LLC, because Bill was very, very helpful, very gracious in educating me, making me aware of different things that I needed to provide for him, as well as just be knowledgeable on how this is going to help protect me. And Bill was great. I mean, I would have never thought that it would have been this simple to go through the process, and Bill just made it so easy that it's really, I kick myself because I should have done this a long time ago.
Well, and we won't divulge your personal information, but we will say that it was also very affordable, right?
Yeah, absolutely. Yeah,
it's not going to break the bank, folks, for you to get an LLC and to get a proper operating agreement if you have more than one member of an LLC, which I would definitely recommend. So anyway, with that, I hope everyone found the show helpful. I hope you'll feel free to call upon me or any other lawyer who professes to have expertise in both estate and asset protection planning, because this is something you guys really need to know and pay attention to. And feel free to go back and listen to the show. You can stop it and play it at your leisure and take more intricate notes. And feel free to call me. I'm happy to provide you with a short transcript of what we discussed here as well, because I think that would be something you want to keep in your hip pocket for a rainy day.
Yeah, absolutely. So, Bill, how do people get a hold of you should they have some questions regarding this topic today?
Well, telephone numbers are both 949 area code. One is 698-6222, and the other is 413-6535, or Bill at wfblegalconsulting.com. Is my email. And of course, the websites are up there. There's PYE365.com for estate planning. There's WFBlegalconsulting.com. And there's also bestemploymentlaw365.com in case you want to know more about employee and employer situations and all the stuff that entails. Mm-hmm. So, with that said, thanks, Rick. Good to see you again this week, and hope everybody enjoyed the show. And we'll sign off, I guess, until next week, right?
Yeah, absolutely. Thanks again, Bill, for all the great information. Folks, if you didn't jot those websites down, go to wfblegalconsulting.com. And if you look at the bottom of that main page, all of Bill's sister sites are listed there. Click on the link, and you'll be directed to each specific website that has to do with the information that you're looking for. So thanks again, Bill, for your expertise and sharing with our audience out there. And we will see everyone again next week or next time here on Tuesday at 10 a.m. here on the Bottled Business Sense Show. So we will see you next time. Have a great week, and we will talk to you soon.
Take care, everybody.